Welcome to the Undiscovered Gems podcast, hosted by NBA legend and business powerhouse Charles D. Smith, highlighting today's best and brightest business minds.
Welcome, everyone, and welcome to Undiscovered Gems. And we are here today with a Diamond Decade attorney. He's also one of 11 attorneys who is considered a living legend for what he does in that great state of Maryland. He's a lawyer that is a fighter. He works for his clients. Welcome, Paul Bekman. And we're going to have a great conversation about him, about what he does. And I don't want to spoil it. Paul, welcome to the show. How are you?
I'm doing great, Charles. How are you?
I'm doing very well. Good to see you again.
My pleasure.
Well, Paul, I'm happy to have you on again because we get to dig a little deeper. We talked a lot last time about your practice, how you feel about your practice, your tenacity, your longevity, but now we're going to dig into the people. We want the people to know more about you, and we want you to talk more about the people who you represent. So, Paul, for our audience, can you start off and just give a synopsis about your career and your background again before we dig into it, because we want them to know really who you are.
So I started practicing law in Baltimore, having worked as a law clerk before I became a lawyer, took the bar exam, worked for a general practice firm that wanted me to learn right away how to try a case. So what did they do? They said, here, Paul, I want you to take these two cases, they're automobile cases where people were injured, and we want you to try them yourself before a jury. And don't worry about them. They're both losers. You're going to lose the case, but you're going to learn a lot about trying a case. So I took the two cases. I hadn't been a lawyer for 30 days, and I won both of them. And after that happened, Charles, I was hooked. That's what I wanted to do. And that's what I've done my whole life as a trial lawyer.
Yeah, you get that feeling of victory, accomplishment, and it's a great feeling. And you search for that feeling throughout your career because you know what it feels like.
And it's not just about me. And I think a lot of people may take it for granted. You know, lawyers say we want to be a winner, but what about the client? The client feels redemption, that they were right and that they were fairly and reasonably compensated for what happened to them. That's where I get a lot of pride for what I do.
Let's talk about that. The client, you've represented countless clients in your career thus far, and you're still continuing to represent clients. How is it when you select a client? Do you still have the same, is it a consistent pattern of pride, energy when you select a client and you get ready to do a case? Is it energetic all the time?
It is for me. And that's because if somebody is contacting me, they're putting their confidence in me. They're selecting me to handle their problem. And of course, sometimes, Charles, because of the work that I do, which is serious, catastrophic type work, there may be issues which will not permit me to take the case. For example, someone is involved in a very serious automobile collision, and they give me the facts of the case, and they tell me that I was driving down the road, I was going the speed limit, I was on a motorcycle, I made a left-hand turn, and somebody who didn't have the right of way hit me. Well, that sounded like fine. So what does Paul do? He investigates it. He gets the police report. He finds out that there are 5 witnesses. And what do? I send out my investigator to talk to the 5 witnesses. And what do they find out? That he was speeding, that he was going 65 miles an hour on his motorcycle in a 30-mile-an-hour zone, that he was weaving in and out, that he was passing other vehicles improperly. And unfortunately, I had to tell him, these are the facts. We're in a state where if you are 1% at fault, you cannot recover. and unfortunately, I cannot handle your case. So
Mm.
there are circumstances where, and I know this will be a shock to you and to people who may be listening, that sometimes people don't tell the truth when they give you how this incident may have occurred.
Mm.
Then there may be another issue. Let's say there is a question of liability. Somebody in a medical situation ends up discovering that they have, for example, a breast mass, and they go to the doctor, and the doctor says, look, this looks suspicious. I think what we ought to do is we ought to have you have a biopsy. Let me send you to a doctor. They take the biopsy, and it comes back benign, and the person is relieved, as they should be. And then as 6 months goes by, lo and behold, the same thing has recurred again. It's grown again. It's bigger. Back to the doctor, back to the biopsy,
Mm-hmm.
cancer. Then they go back and they look at the original biopsy, and lo and behold, it was cancer then. It was misread. Somebody did something wrong. But within the 6-month period, fortunately, the cancer could be taken care of. So the delay of 6 months was not causative in their problem. And unfortunately, for the person, they cannot proceed with a case.
Mm.
Or another example, and this happens unfortunately, somebody says, look, I've got a problem here. I have problems urinating, going to the bathroom. I've got pain. They evaluate the person, and lo and behold, they determine that the person has prostate cancer. And is it in stage 1 or stage 2 or stage 3, or is it stage 4? And if your cancer is stage 4, the result, unfortunately, is one that not a result
Mm.
of medical negligence. So you have a causation issue. You have to show that more likely than not, which is 50%, it would have been able to have been taken care of earlier, but not when you're stage 4 or even in stage 3. And that happens also. So causation, in addition to the issue of liability, is important. And then you get to the third issue. And the third issue is damage. What are the damages? Somebody goes in for surgery on their knee, and after the surgery, they feel fine. But come 2 years later, 3 years later, they got a pain in the same knee. And they go back to the doctor, and the doctor looks at it and says, I really think you ought to have an x-ray. And lo and behold, they do an x-ray, and in the knee, there's a foreign body that didn't give them problems until 2 or 3 years later, which would be okay under what's called a discovery rule. They didn't know they had an injury. They didn't have a problem. But they end up taking out this needle that may have been left in. And what are the damages? They remove the needle, and they're fine. Where's the case? Liability, causation, and now damages. The damages do not justify moving ahead. So those are a couple of examples of how you've got to have all three in order to be a winner.
Liability, causation, and damages.
Yes.
Got it. Got it. That's
And then,
great.
you have the issue of somebody who comes in and says, look, my car malfunctioned. It didn't work right. I couldn't control it. I ended up going off the roadway and hitting a tree. And my car is demolished, and I was injured. And let's just assume, for the sake of argument, that there was something that was wrong, and the car had been recalled. but the person was never sent a notice. So
Mm.
you have liability, you have causation, but what about damages? How serious are the damages? You're going to take on whatever company it is, Ford, Chrysler, Tesla,
Mm-hmm.
and the question becomes, is it going to be worth your while? Because those are the cases that are extremely expensive. Product liability cases are probably the most expensive case to bring. So all
Yeah.
of that has to be evaluated.
So, that's a good point. Let's talk about the client when it comes, or you when it comes to fees, pro bono. When you're taking on, I'm forgetting the word, when you're taking on a case and you're just dealing with the end result, and you might not be paid up front, but it's a contingency. Yeah, it just
Correct.
hit me. Right.
Correct.
So contingent. So how do you judge that? You just mentioned that those are
That's a
expensive.
really, really good question. And you can talk to a lot of lawyers who do this, and they will tell you that if they're taking a medical malpractice case or if they're taking a product liability case, they're going to charge 40% of contingency. They'll front
Okay.
all the money for the case, they'll undertake the case, and then at the conclusion of the case, there will be expenses which they'll be reimbursed if they win or if they settle, and they'll charge the 40% fee. If I handle a case, I will not handle it on a 40% contingency. I charge a
Mm.
third. A third is fair. And
Mhm.
if it turns out that I don't have to try the case, but it can be settled before a trial and without the substantial improvement, work to be done, like you're right at the courthouse steps, I'll reduce my fee. And I'm a believer that it's a lawyer's obligation to be fair to the client, and I will reduce my fee, particularly if it turns out that the client is not going to get that much money because the circumstances are such that you can't get it. But even
Mm.
so, if I don't, even in a big case, I will reduce my fee because it's the right thing to do.
Right. So you're essentially doing all your due diligence before you do a contingency case. You
Correct.
you you have to know that you're
Absolutely.
going to win the case. Has
Right.
there ever been a time where you've relied on an investigator for you, do a contingency case, and the investigator screwed up, and you either didn't get what you were supposed to get? It turned out to be maybe you got an education, but a royal waste of time economically. Has that ever happened to you?
That fortunately has not happened to me. I've got really good people who work, but you raise a very good example, and that is this. What if you have a medical negligence case and you
Mm-hmm.
hire an expert, which you need to have, and the expert ends up coming up with an opinion that is just not sustainable? It might win your case, but he or she is wrong. And the other side has three experts who are going to say that your expert is wrong, your case is wrong, and you don't have liability and you don't have causation, and you lose. And that is why, in cases involving medical negligence, you cannot just rely on one person. You have to have multiple people,
Right.
which confirms that you're right. And then you're
Mm.
okay. And you got a fair shot at winning the case.
Right.
And that
Oh,
and that's
what
why
about?
these cases are
Yeah,
expensive to bring.
got it. Um, what about families? And you take on a case, and you're dealing with casualty, you're dealing with products, medical malpractice. Tell us about when you had to actually deal with the entire family, because sometimes when a person in a home has cancer, the whole house has cancer, family, because everybody's got to deal with it. And you might have a client that might be young, but you got to deal with the parents, you got to deal with the brother, the sister. They're all involved in this point, and you got to hear from all of them, and you got to be considerate. But at the same time, it's more emotional, personal. But you just got to stand on the red carpet and deal with it. Talk about that.
It's a really good issue to deal with, because in cases involving somebody who is going to die or has died, the law says that there are certain beneficiaries: spouse, children, parents, all of whom are involved. And as you might expect, in some cases, not all, some people feel that they were closer to the person that died than their sister or brother, or mother. And what we have to do as a lawyer is to try to explain that the best way to handle this is for everybody to work together. And if the case goes to trial, the jury will determine what each beneficiary gets. And there's a specific verdict sheet that identifies each person. Sometimes, and this has happened a number of times, there may be a member of the family who is long lost and gone. They just abandoned the family. And then when the death occurs, they come back. You can imagine how that person is dealt with as far as the family is concerned. But what I say to the family is, look, you're all in this together. If you present a joint front, you're all going to do better than if you fight with one another. And the same thing holds true about a settlement. You settle the case, and then you have this whole issue: who gets what?
Right.
The spouse is number one. The children may be number two, or it could be the parents. And what we always try to do is to get them to agree. But let's say they don't. What do? What you end up having to do is you get the funds, and then you go to court, and the court determines, based on testimony that will be given, who is entitled to what. It's a bad case to bring. And as a lawyer, the lawyer who handles the case can't represent everybody. There's a conflict. So everybody has to get a lawyer. So imagine the costs in doing that and how that looks. So yes, dealing sometimes with families, and there are some times that are people that are very stubborn. They believe they're number one when they may not be number one. And I always urge the people to give consideration to being treated equally, unless there's some special circumstances.
Right. Paul, you mentioned the word conflict. Has there ever been a case that you've taken where legally, you it's not a conflict, but you've run into a situation where there might be a moral conflict or a personal conflict, and you decided not to take the case? Have you ever been in a situation like that?
Yeah, unfortunately, that does happen from time to time, where you find out that the person, for example, who may be the person who is being sued, is someone who knows your family, or who knows your wife, or who knows your children. And that kind of a conflict, I think, is one where, I would bow out and I would have somebody else handle the case, because it's not right to do that if you can't fully and completely represent your client. So make sure that they get somebody who can, and that has been done. Right.
What about, for lack of a better phrase, a bad case? And what I mean by that, you've taken a case on that you believe in the person, you don't think they're going to win, but you've taken the case on. And for whatever reason, talk about that.
Well, those cases happen, as you know, because something may have been done which was not right. And what ends up happening is the case ends up going to a jury. Now, things may vary from state to state. Everybody thinks that, there are 12-person juries. In our state and in our federal court as well, there's 6-person juries. 6 persons on the jury.
Hmm.
And as you might know, in knowing people, there are 6 people who may have totally different feelings than you. And sometimes what ends up happening, and it's happened to me, is you try the case and you end up having what's called a hung jury,
Right.
because the jury in our state has to be unanimous and somebody is holding out. There's something that doesn't jive with that juror. So it's 5-1, and the judge instructs them, go back, reconsider your position, think about what the other side is saying. We'll give you another chance. And they come back and they're still hung. So there
Right.
you are with no result, a lot of time, a lot of effort, and a lot of expense. Some people say that a hung jury is like kissing your sister. Now, I don't think there's anything bad about kissing your sister, but that's what happens sometimes. Hung
Right.
jury. And
Right.
you like to think that if you've been practicing for a long time and you can evaluate a case, you can tell a winner from a loser. But
Mm-hmm.
there are so many different things that can happen where people may be affected one way or another that will change the whole scenario.
Yeah. When you talk about a hung jury, it makes me think of when people say, they talk about the quote unquote the system, and the juries can be a part of the system. There's times where it's public sentiment that, this person deserves X in a good way. But somehow you just mentioned the jury, it flips and it goes the other direction because of one or two people in the jury.
It's
Um,
absolutely true.
I know it's critical in selecting jurors. How does that work for you in your cases?
Well, again, it varies from state to state. In our
Mm.
jurisdiction, you have to give the court the questions to ask the jury, and the court has to approve those questions. So you don't get,
I
like
see.
in New York, where I tried a malpractice case in Poughkeepsie for 5 weeks. They have individual, what's called voir dire. You get to question each person who is being put up as a juror. I
Oh,
find that
wow.
to be fascinating and extremely helpful. And you can get views. And then
Mm,
when you finish your case, you can remind the jury of the questions that they were asked, as they may bear on the ultimate result. I find that to be very helpful. But
mm.
some places are more interested in efficiency than they are in time. And it takes more time, but I would go for it very much so. Same thing happened in Virginia, individual
Right.
voir dire.
How do you find it helpful and how do you use the information?
So it's always interesting when you get certain information about, what jurors think about
Sure.
what their feelings are about certain things. Do you have a problem with X? Do you have a problem with Y? For example, sometimes you may represent a client that might have a criminal record in a civil case. Would the fact that this person had a conviction for X make a difference in your view of the person? If the person, for example, went to jail, served 30 days, turned their life around, and is a fine, upstanding citizen, would you hold that against them? Some people
Right.
would, some people wouldn't. So
Right.
it's every individual is different, as we all know. We all have our crosses to bear in some
Yeah.
respect or another. What's
Sure.
important to us may not be important to them. And being able to find out how they feel and what their opinions are is a big help in selecting a jury that's going to be fair. That's all you want.
Mm.
Listen to the evidence, rely on the evidence, listen to the arguments of counsel, and then make a fair and reasonable decision. That's all we can ask.
Right. Paul, you sometimes, I guess, you've taken on some public cases that are in the press. How do you deal with your client when it comes to, you're an attorney, you're not a PR person. However, you want to try to control that to an extent. You have to have the conversation with your clients about what to say and what not to say when you leave your office, and because it can impact the case. How do you deal with that? And talk about one of those type cases.
Well, so it's really, Charles, in every case now. Example: social media has changed the ability of lawyers to find out about clients. What do I mean? Facebook. If you have somebody who is a frequenter of Facebook and they're posting things which may be totally inconsistent with what they say in the courtroom, you've got very damaging evidence. For example, person comes in and they have a terrible scar on their neck as a result of an injury that occurred.
Sure.
And they had surgery. And they come into the courtroom and they're wearing something that shields their neck so you can't see the scar because they're conscious of the scar. And they get on the witness stand and they testify how important it is to them that I don't want anyone to see because they'll be looking at me and they'll be looking at that scar. And that's what they're going to think about me. And
right.
I just don't want that. And then on cross-examination, the defense lawyer brings up the Facebook page of the person at the beach with a top on that you could see everything, and person is running around and having fun, and then comes in and they go to the bar and they're sitting at the bar. What's the credibility of that person?
Right.
So here we have Facebook, Twitter, emails.
Sure.
All over the place. And believe me, the other side will be looking at it.
Yes. That's a great point in today's society. Paul, again, time flies every time I talk to you. So much impactful information to help others with your thought process and how you conduct your work on a daily basis. Got to wrap this up, Paul. Give the audience one last thought about yourself and how you represent your clients and how you go about it.
Well, I take it very seriously that every person that contacts me is deserved of time. And even if I don't handle the case, I might refer them to somebody else who might. But I'm very conscious about making sure that people are fair and just and give the image of a lawyer that they should give, that you're there to try to help people. And
right.
Yes, in many cases you will be able to, but in others you may not. But be honest, be direct, and be fair.
Thank you. Paul Bekman, thank you for your time, your wisdom, and your knowledge. Such a great show. Appreciate you. Thank you.
Thanks, Charles. Great to see you.
Have a good one.
You too.
We hope you enjoyed this episode of Undiscovered Gems with our host, Charles D. Smith, highlighting today's best and brightest business minds. Brought to you by Pods Entertainment Group.
Adopt US Kids presents Multiple Choice Parenting.
Your daughter just had her first breakup. Do you A, put yourself in her shoes?
How could he do this to you? And for Sheila, she has split ends.
B, console her?
Oh, sweetie, this is going to happen a lot. 4, maybe 5 more times before you get married.
C, take charge?
Got to get this all straightened out. Give a little talking to, man, mano a mano. Hey, Steve! It's now a good time? No? Okay, no problem. Bye.
Or D, help her find a new boyfriend.
I know a great place to meet boys. The internet. Nice, single boys. Never mind. How about some ice cream?
As a parent, there are no perfect answers. But you don't have to be perfect to be a perfect parent. Thousands of teens in foster care will love you just the same.
For more information on how you can adopt, visit adoptuskids.org. A public service announcement from the U.S. Department of Health and Human Services, Adopt U.S. Kids, and the Ad Council.